During my presentation, I will put emphasis on two main topics. And these two main topics are pertaining to small consignment regulations. For your information, I'd like to highlight that you are well aware that in December 2017, new law on border measures related to intellectual property has been passed, and the Revenue Service of Georgia tried to work on this regulation in order to be in fully harmonization with the EU regulation, 608, but it would be impossible to put this into practice. And at that time, it seems that small consignment regulation consideration did not take place. You know that according to the current legislation, initiation, as soon as the Customs Department makes decision to suspend the goods, this initiation is in the competence of a right holder. He tries to have contact with importer to have further negotiation, and in this case, court application is the last resort and not desirable one. Meanwhile, I'd like to tell you about the innovation or news that in the wake of pandemic, the demand has drastically plummeted. Therefore, nearly all companies, so pandemic has impacted negatively on these companies, and the companies' budget was reduced. I'd like to highlight that from large-scale companies, we get some kind of requirement or demand not to respond to customs service because they did not have any budget to pursue custom-related procedures. We explained these companies that it was impossible to do this, and therefore it was kind of our investment in this process. We took this responsibility. For the first 6 months, we have had very close cooperation and communication with the Customs Department when the pandemic arose. So, why I am highlighting this matter? I'm highlighting this matter for you to have a vision regarding the scale of regarding the company's budget shrinking. And one of the companies made an argument that I had to close all shops in US, and this was kind of a justification of their demand. And it indicated or demonstrated the scope of economic burden companies faced with in the wake of pandemic. So we do realize and we do tell companies that with above mentioned resulted in companies' inability to follow zero tolerance policy and pursue cases regarding small consignment in the court when importer does not agree to sign destruction agreement. But in the, on the background of this crisis, not all companies are able to apply this policy, especially For example, in May, we had a case when the several suspensions took place in May. There were some small consignments, for example, 10 or 20 items, for example, of shoes, and the companies refused to sign a destruction agreement, and they said that I am not able to pursue 3 lawsuits in court. This was a case that happened in May, and we also raised this issue regarding the information providing and communication to Customs Department. We said that, wrote them that we were not able to provide this information to Customs Department, and we asked this company to sign on this letter and so forth and so forth. So this was the matter that took place a few months ago. Mrs. Nana signs this letter in Amsterdam, and you can apply to her. So very pressing issue raised. How to be in fully compliance with the EU regulation, Article 26, regarding a small consignment destruction by Customs Department. The meaning of this article is that during suspension of small consignment, Customs Department informs right holder. Right holder confirms that this is counterfeit, and in this case, Customs Department provides information to importer to present its position. If importer does not respond to this notification, or this response is not well substantiated, the Customs Department makes decision to destroy this small consignment. Within EU, Customs Department destructs this counterfeit good within its by its own resources. Mr. Samson will correct me if I'm mistaken. That is the advantage of this principle is that importer takes this initiative. So importer is forced to take initiative. There were some cases when importer refused to have communication with us, and this is a signal for us that importer is not ready to sign on a destruction agreement, and this is the last resort to apply to the court. And that's why we needed to ask a question to Customs Department whether it is reasonable for him to introduce this approach or principle in Georgia or not. Also, we can use this approach in other cases as well in order to solve communication problem with importers. We do have this problems or challenges with importers in terms of communication. It is keeping in mind Customs Department resources for destruction. We may not introduce or copy paste this regulation, and we may maintain or retain this destruction ability, and copywriter can do it, but this is very outstanding issue, especially in the wake of pandemic. That means that it is very extremely difficult or complex to apply to court because the companies do not have the sufficient capacity or financial ability to do this. Also, Article 26 that I highlighted is properly balanced and is not violated, and this decision does not damage importers' interests. Also, I'd like to underline another topic that was highlighted by Mr. Ulidia regarding Exofficial. I'd like to highlight two important topics regarding this matter. So the very first topic is that what hinders us to what hinders us to extend this duration and to have 10 days except for instead of two working days. For Article 4.3 of the new law prescribes 2 working day term for submitting a complete application by the right holder to Customs Department, supported by apostilled or legalized power of attorney in cases when Customs Department exercises ex officio power. Now, we do understand that communication may begin earlier, and if a party or side desires, they can extend the term, but it would be better for us to extend this term to up to 10 working days, and the Customs Department's viewpoint would be very interesting regarding the extension of term. Also, Mr. Urdia mentioned that there are frequent cases when there is no response, or they have a response on specific suspension, but it does not turn into permanent registration. Also, Mr. Samson underscored that it seems that Customs Department or Customs Department follows the rule that they apply to SAC patent regarding to provide to get information regarding the right holder. Definitely, we are not against to this approach, but in 2019 we had an attempt to sign a memorandum, but we failed to sign this memorandum. I applied to you on behalf of organization REACT. I am representative from it, and there are large scale as well as SMEs up to 300 companies, and REACT could take responsibility to exchange information with Customs Department in order to help you ex officio related matters. I suggest you to sign this memorandum, and this memorandum will be very important step moved forward to have direct contact with importers and not to search for this information in internet. So it will be very good and useful communication tool for you. And I do not think that other organizations refuse to have communication with, for example, organization UNITA that is intensively being presented in different conferences. For example, in Batumi conference, they took part in Batumi conference. So I think that you can apply to not only SACPAIDEN, but to other associations and organizations as well. And your cooperation with these organizations will be very fruitful and very helpful. This was about the presentation.